Welcome. We are visiting the trial procedures steps, and the culmination step is the judgment in the form of conviction or acquittal of the person on trial. Once this judgment is pronounced, then we have to visit the provisions as to what are the legislative steps provided as a form of further re-adjudication, revisiting of the total trial material on record. It is called an appeal. Now, the appeal provisions are there with respect to the final orders. Interlocutory orders, the orders in between stages, come within the category of the revisions or the other supervisory steps provided on the administrative side as well as on the judicial side. This also takes a branch where we go and exercise and invoke the jurisdiction by way of writs of the high courts and the Supreme Courts. Now, as far as these provisions of reference, revision, appeal, second appeal, writs, special petitions, provisions are there, these all inherently accept that the judicial apparatus is to function through human beings. As the apparatus is to function through human beings, therefore there are bound to be human factors. So idealism and the reality is to be visited in the context of the human factors. The provision for revision or provision for appeal is there as man is fallible, as institutions are to function through human beings. Therefore, those human factors will come in. These factors will be firstly in the form of inefficiency, secondly in the form of non-sincerity, and then further there could be more distortions as well. We as students of law have to first of all visit what precisely the law provides. Law, from the individual's point of view, is many times taken as a common sense. However, the legislative laws, the institutional apparatus, functional apparatus of the state through human factors, as such, is collection of the collective wisdom. The distinction is to be maintained between the common sense expectations and collective wisdom reach. Therefore, many times the common sense indicates that the law should be like this, and the collective wisdom also points out as to the expectation, the collective expectation is the law should be in this form. In between, there are many situations. We as lawyers, when are representing our clients, maybe the victim or maybe the assailant, or so the accused when is on trial, and there is a judgment of conviction, and one is not satisfied with the process or otherwise conclusions of the trial procedure, then one can go for an appeal. Even if one is acquitted, the victim may feel being not satisfied, and there is a provision for appeal against acquittals as well. The Chapter 29 is a collection of the legislative permitted steps. From 372 onwards, the provisions or as to no appeal to lie unless otherwise provided. Therefore, appeal as such is a legislative permission. If legislature doesn't provide, and if there is no specific provision for appeal, then there is no right of an appeal. So if we have to go for an appeal, then we have to bring it within the four corners of the sanctions of this chapter of appeals. Then different situations are provided. Appeals from orders requiring security, a refusal to accept or rejecting surety for keeping peace or good behavior, appeals from convictions, and then no appeal in certain cases when accused pleads guilty. This also is one situation where one is not permitted to appeal once one admits his guilt. Then no appeal in petty cases. Appeal by the state against sentence is provided. Appeal in case of acquittal is provided. Appeal against conviction by High Court in certain cases to be filed in Supreme Court. The special rights of appeal in certain cases, and appeal to Court of Sessions, how it is to be heard. Petition of appeal, what are the ingredients of it, procedure when appellant in jail, summary disposal of appeal, procedure for hearing appeals not dismissed summarily, powers of the appellate court, judgments of subordinate appellate court, order of High Court on appeal to be certified to lower court, suspension of sentence pending the appeal, release of appellant on bail, arrest of accused in appeal from acquittal, appellate court may take further evidence or direct it to be taken. It is one clause, one section in which it is specifically provided that appellate court may take further evidence or direct it to be taken by the trial court. It is this provision which deserves to be visited more intimately, as it is here where there is a chance that one may bring another material on record which for some reasons couldn't be reduced or adduced or accepted during the trial procedure. Then procedure where judges of the Court of Appeal are equally divided, send it to another bench, finality of judgments and orders on appeal, abatement of appeals in case of death and other situations. Now see, we have to be through these provisions as lawyers to understand as to which situations have been accepted by the legislature, by the law, in which the appeal is to be preferred and to be got adjudicated, and particular steps or situations which will be covered during the appeal, or what the appeal procedure is going to be. Now it is here where we have to come back to the original stage of framing of a charge. In fact, the framing of charge is the first foundational step with respect to which we shall have a full attention. It is the charge which is to be put upon trial. And charge essentially takes us to the ingredients of the offense for which charge is to be tried. Therefore, we as students of law, or we as lawyers, have to revisit each offense for its ingredients. So the core of understanding and core of the challenge is that we shall fully imbibe the features of distinct ingredients of an offense. It is only with understanding of the ingredients, the features of the ingredients of the offense, that the entire rest superstructure of trial is to be built. Therefore, we shall take up each offense, maybe under IPC or under any other law. Then that offense is to be dissected in its ingredients. It is this dissection of the offense into its ingredients which is essentially the basic foundational setup for the trial and further consequences thereof. Now, each ingredient is to be proved, and proof is to be in terms of an evidence, and evidence is to be of the facts. Therefore, in the context of offense, we have to reach at its ingredients. We have to dissect the offense into ingredients. Then each ingredient is to be visited for the features which constitute that ingredient. Now, the features of each ingredient as such are to be traced back to the facts which are making those features. That means we have to enlist the facts. We have to tabulate the facts for each feature of each ingredient of each offense, means each charge. Charge can be of many heads. Each head of charge is to be with respect to a particular offense. Each offense is a setup of specific ingredients. Each ingredient is a set of features. Each feature in itself may be a collection of facts. So, while we have to prepare the case of prosecution or of the defense, then we shall be very, very vigilant. We have to be conscious. We have to be specific. We have to be fully prepared. And in that preparation, the first need would be that we shall have one sheet with us which takes us from the charge to different heads of charge to the different offenses of different charge heads. Then each offense, each charge head is to be taken to the ingredients of that particular offense. Then each ingredient is to be taken to its features. And the features, again, feature-wise, are to be taken to the fact or facts which will prove or disprove the particular feature, then particular ingredient, then particular offense, then particular head of charge, and ultimately the total charge, and hence the consequential final result in the form of conviction or acquittal. So there is a very big chain, and it is this chain which is to be built. If it is broken at any in between stages for the prosecution, the prosecution is to suffer. If it could not be broken by the defense, then defense is to fail. Therefore, we as lawyers shall approach IPC and other offenses codes offense-wise. We shall understand each offense in terms of the ingredients which constitute that offense. And once we will be having a list of ingredients of offenses, then we'll see that many ingredients are going to be common, like mensa rea. Whether or not here in this commission is mensa rea or not. Once we will be visiting the features of the mensa rea as ingredient, then naturally it will take us to the mind, to the mental state, and in it we will reach at the determination, the decision, the conscious decision. So how mensa rea is to be reached at, how mensa rea is to be proved, how mensa rea proof is to be met, is to be rejected. Therefore, the growth, richness of the wisdom and experience of a liar may be ultimately having one index factor, and same is going to be the extent to which a liar can dive deep for proof or disproof of the ingredient of a mensa rea. It is here where from we have to begin, and it is here where ultimately we have to end, while we will be having appreciation of the ingredients aspect. Therefore, the first thing which each one of us is to be vigilant is at the initial, very first stage of the trial, when the prosecutor under section 226 Code of Criminal Procedure will be opening his case. Now, as we have seen that the case is to be opened firstly for the charge for which the prosecutor prays that accused is to be put up on trial. The second aspect is the evidence in terms of which prosecutor wants the court to conduct the trial. Now, see, the charge, as we have taken, say, with respect of the ingredient of mensa rea, and the evidence as well is to be directly visited as to what is that evidence in terms of which the prosecution is intending, is implying to prove the mensa rea. Likewise, the evidence which is put forward by the prosecutor is to be analyzed, is to be categorized, is to be specified, is to be coordinated, and is to be correlated with each ingredient of each offense of the charge. Now, if we are specific, if we are clear, if we are conscious, if we are having a complete vision about this legal requirement of direct coordination between the features of the ingredients and the facts with respect to which the required evidence is to be led. Therefore, at the first date of hearing itself, we, each one of us, maybe prosecutor, maybe the defense counsel, and even the court as well, have to be conscious as that how the bridge or chain of bridges are going to be built between the charge heads ingredients or features, and the evidence pieces as chain of facts. So facts with respect to which the evidence is being pointed, and the natural logical reach in terms of those facts. If the same is parallel with the lawful expectations of reach till the features of ingredient, each of the ingredient, then it is only in terms of this vision. It is only in terms of this comprehension. It is only by having this imbibing that we can, at the initial stage itself, can come to the conclusion and make a submission with the court that this is a case for framing of a charge, or this is a case for discharge. Now, charge is to be framed only if prima facie that bridging is there. Discharge is to be there if one or more bridges are not in their place. So the submissions at the stage of framing or not framing of charge, in fact, is going to be the first judicial mind being applied thereto. Therefore, this order, in fact, is going to be the first stage of the judgment, judicial mind application to the charge being proposed and the evidence being submitted. Therefore, one has to be very, very certain in one's mind whether or not at that phase and stage accused is entitled for discharge. See, practically, when the defense plans to submit at this stage of charge is that charge, if results into discharge, then there can be a prosecution at the near future as well. But once there is an acquittal, then there cannot be a second trial for the same charge. So many times in practice, the conscious option is taken by the defense that let the charge be framed and all the deficiencies and loopholes or weaknesses of the prosecution will be availed at the time of the final judgment. So acquittal is better than a discharge. Otherwise, it also is a fact that many times those weaknesses which stand ignored at the time of framing of charge gives a chance, a conscious chance to the prosecution to have further additional evidence, and those weaknesses which at the initial stage may have given the relief of a discharge, the same may not be available subsequently. Therefore, this exercise of mind, this discretion or this option at the stage of the charge is to be exercised consciously and in a most realistic frame. And it is this choice determination which in fact is going to be as per the wisdom and experience of the defense counsel. Thank you very much.
Thank you, sir.